Hi, I'm Phil Neale. Welcome to today's quick video insight from Holmquist and Gardner. Today we are going to be going through easements. I'll be discussing different types of easements, requirements of easements. I'll quickly go through key provisions in easement agreements and why it is important to have easements in writing. Please note that this video is not intended to serve as legal advice and is for informational purposes only. So first, what is an easement? An easement is a non-possessory right to property that allows the holder to use another person's land for a specific limited purpose. So examples could include access roads, utility lines, drainage, wells. So a few types of easements. There are appurtenant easements. These easements usually benefit a particular property and burden another property. You have two estates involved. There's the dominant estate and the servient estate. The dominant estate is the estate that benefits from the easement, and the servient estate is the estate that is burdened by the easement. Easy example would be a driveway easement that allows access to a landlocked parcel. So the driveway in this case would run over the servient easement and it would connect to the dominant easement. These run with the land typically in perpetuity and therefore transfer automatically when the property transfers. This is true for property burdened by easement and property benefited by easement. You also have easements in gross. Here, there is no benefit parcel. The benefit is to the holder. For example, it could be a utility company. These types of easements are in fact very common for utility companies. For example, easements for power lines or for sewer access. These easements are again tied to an entity, not to a parcel of land, but they do burden a parcel of land. Quick example here would be Puget Sound Energy. They might have an easement to maintain power lines over a parcel. So how are easements created? They are created either by agreement or granted in writing, or sometimes they are not by agreement. Sometimes you could have an easement by prescription. So what is a prescriptive easement? A prescriptive easement is established by a claimant's well-established long-term use of another's land. There are certain elements that must be met. Use must be hostile. In other words, the user must have no permission from the owner. The use must be open and notorious. It must be continuous through the statutory period, 10 years in Washington. It must be exclusive, and it must be over a uniform route. You could also have easements by necessity. These arise when there's no other reasonable way for a property owner to access their land. It often occurs in a context where a property is landlocked and requires access through a neighbor's property. I want to cover a little bit about RCW 64.04.010. So the statute's purpose is to ensure clarity, permanence, and enforceability of property interests. So easements, it's important to note, are considered interests in land, so they fall under the same formalities as deeds. If an easement is not in writing, it may be deemed invalid or unenforceable unless it qualifies, for example, as a prescriptive easement or an implied easement. Deeds, if they are in writing, they need to be signed and notarized. Notarization is important because it verifies identity and prevents fraud. So only the grantor needs to sign, but it's best if both parties sign off for clarity or if there are mutual obligations such as maintenance responsibilities or indemnities in the agreement. So the easement should also include a legal description of the burdened parcel or the servient estate. The servient estate is the property burdened by the easement. A legal description of that property should be part of the easement. The legal description would include metes and bounds, lot/block number, or parcel numbers. You can refer to the vesting deed here. For appurtenant easements, the dominant estate is the property benefited by the easement. It should similarly be described like the servient estate. Although a legal description of the easement area is not required, it's very helpful to have it in your easement agreement, and the best practice is to include it. At the minimum, the easement area should be clearly described. An additional exhibit with a depiction of the easement area in the form of a sketch is not required, but it is a good practice. Also a good practice to have the surveyor's meets and bounds description along with the drawing. So next I want to discuss recording. Recording the easement puts the world on constructive notice. Without recording, a subsequent owner of a property burdened by the easement may be able to claim bona fide purchaser status to defeat the easement. So recorded easement is superior to later claims by buyers or lenders who don't know about it. If a real property bound by an easement or to be bound by an easement is encumbered by a deed of trust, for example, in a home loan, it is important to check with legal counsel on whether or not lender's consent should be obtained prior to recording the easement. So a few key provisions in easements that should be considered carefully. One is purpose of the easement. You also have maintenance requirements / obligations, who's responsible for maintaining and repairing the easement. Cost sharing, maybe they're shared, maybe costs are shared proportionately to use. Remedies and enforcement of easement rights. Maybe there's an insurance provision. Perhaps grantee is required to maintain insurance. Maybe grantor should be named as an additional insured. Indemnification, is grantee required to indemnify grantor? Dispute resolution and attorney's fees provisions. Note that if you don't have a written agreement, there is no common law or statutory right to attorney's fees in any easement disputes. Thank you for watching this Holmquist and Gardner Quick Insight. Again, this video is not intended to serve as legal advice and is for informational purposes only. We appreciate you joining us today.